So we have some important news in the battle to end the NFA's restrictions on things like suppressors and SBRs. Now, the recent decision by the Fifth Circuit protecting the NFA's restrictions on suppressors is heading for re-review in the en banc panel. Now, this comes after the Trump DOJ recently changed their position on suppressors and argued that they are protected arms. But the Trump DOJ is now trying to use that case in that ruling that went in their favor to now block a new lawsuit seeking to end the NFA outright after the recent $0 tax change that happened in the Big Beautiful Bill. So let's talk about what is now happening in these critical cases. Now, before we jump into this video, I just wanted to wish everybody a happy Thanksgiving. I hope you guys are enjoying your time with your friends and family. Also, if you want to support the channel, one of the best ways to do that is simply to subscribe. Also, double check to make sure YouTube is not unsubscribed you, because they love to do that, especially on two-way channels. Now, as I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge, but also some of the SBR challenges in the NFA $0 tax lawsuits that are currently going on. And we're going to be talking about how this specific suppressor case that was ruled on by the Fifth Circuit is now impacting all of those other NFA cases. Now, this case, U.S. versus Peterson, deals with the constitutionality of the NFA as it applies to suppressors. Now, on first review of this case, the Fifth Circuit 3-judge panel found that suppressors are not arms, and because of that, they do not have two-way protections. However, the Trump DOJ, in their first brief to the Fifth Circuit en banc panel in this Peterson case, stated that suppressors are arms and that they cannot be outright banned. But at the same time, in that same very argument, they also stated that the NFA's restrictions do not amount to an outright ban on these items, and they also argued that the NFA operates as a simple shall issue permit with a modest restriction on these items, which is allowed under Bruin. The Fifth Circuit recently redecided and re-ruled in this case, and they agreed with the Trump DOJ, and now the DOJ is trying to use that ruling here in this suppressor case, the Peterson challenge, to also strike down some other NFA lawsuits that are trying to expand upon what happened in the One Big Beautiful Bill with the reduction of the NFA tax to $0. Recently, two-way organizations have filed lawsuits trying to end the NFA nationwide based on the changes to the $0 tax, taking NFA tax requirements from $200 to $0 that was passed in the One Big Beautiful Bill. However, in these cases, the Trump DOJ is now arguing that this Peterson case blocks those challenges since the Fifth Circuit already found that the NFA's restrictions on suppressors is permissible, and it's a permissible shall issue permit. This is all happening while the Peterson case is also currently trying to get Fifth Circuit en banc panel review. So although there is that ruling by the Fifth Circuit in this Peterson case, it is not yet final. Currently, Peterson is trying to get en banc panel review, but still the Trump DOJ is trying to use this case to block other lawsuits. Now, for those not aware, in this Peterson case, essentially back in 2022, both federal and state law enforcement officers executed warrants against Mr. Peterson's home in Louisiana. He had a home-based FFL. He was raided by 50-plus law enforcement agents. Now, during this entire raid, the only thing that really jammed up Mr. Peterson was the fact that they found an unregistered solvent trap in his home, in his actual bedroom safe, and it's because of that one item that was not registered on the NFA as a suppressor that he got a NFA charge in violation against him. In response to that charge, Mr. Peterson filed a motion to dismiss in the district court in his case. He argued based on the Second Amendment, but on review, the lower court denied that, and then he had to appeal up to the Fifth Circuit for reversal. Now, on original review, the Fifth Circuit 3-judge panel sided with the then Biden ATF and DOJ. The Fifth Circuit found that a suppressor is not a necessary accoutrement of a firearm that is required to make a firearm useful or functional. Now, Mr. Peterson and his counsel then decided to seek rehearing en banc in the Fifth Circuit, but like I mentioned, that petition was later pulled and the original decision was removed, and the 3-judge panel had to re-review this case because the Trump DOJ actually shifted position and policies on suppressors, and they admitted to the courts that they are in fact protected arms. Well, even after all of that, the 3-judge panel still upheld the NFA's restriction on a new ruling in this case, and the Fifth Circuit still found that they believe suppressors, even though they may be protected arms, can be restricted because these type of NFA restrictions operates as a shall issue permit, and they argue that shall issue permits like this one are allowed under Bruin. Now, under Bruin's dicta, which was issued by the Supreme Court in a 6-3 ruling, there was some concurrences and statements by Justice Kavanaugh where he talked about how CCW schemes may be generally permissible if they apply objective criteria like background checks, fingerprinting, and other objective things like fees. But here the Fifth Circuit twisted that Supreme Court ruling on CCW permits and shall issue permits, and they used that to justify the NFA's registration and taxation scheme. That is why the Peterson case was so concerning. In essence, the Fifth Circuit's holding kind of stands for the proposition now that any permit system restricting 2A rights or access to firearms may be allowed as long as it operates objectively according to the government. However, that decision is now being challenged and en banc panel review is being sought by Mr. Peterson, but still, like I mentioned, that ruling by the Fifth Circuit is now being used in other NFA challenges. The Trump DOJ claims that the Peterson decision actually blocks the $0 tax lawsuit that have now been brought and are trying to eliminate all the remaining NFA restrictions because there's no longer a tax on items like suppressors, SBRs, and other items because of the One Big Beautiful Bill. This came in a case called Jensen, and in that case, the DOJ recently argued that the Fifth Circuit's decision in U.S. versus Peterson forecloses plaintiffs' Second Amendment claim, at least insofar as it pertains to suppressors. There, the Fifth Circuit held that even assuming suppressors enjoy Second Amendment protections, the NFA's regulation of suppressors is presumptively lawful, like the shall issue licensing schemes that the Supreme Court addressed in Bruin. Given this presumption, the court explained that the NFA's requirements will be subject to a second step of Bruin analysis, i.e., whether the law comports with the nation's historical tradition of firearms regulations, only if a challenger can show that the requirements have been put toward abusive ends through exorbitant fees or lengthy wait times for the application approval. Plaintiffs spend pages upon pages explaining why they believe Peterson was wrongly decided and suggesting that this court brush it aside. Whatever the merits of those criticisms, this court is bound by Peterson unless and until the en banc panel of the Fifth Circuit or the Supreme Court overturns it. So even though the Peterson case did not talk about the new $0 tax change because of the One Big Beautiful Bill, the Trump DOJ is trying to use that ruling to actually block these new lawsuits, which are trying to play off that tax change that just happened. They argue that until the Fifth Circuit or the Supreme Court reverses that ruling, the new case cannot move forward. This, other challenges with the NFA and the, trying to get rid of the NFA completely based on the tax change, all of those should be dismissed until Peterson is resolved or reversed. There is also the underlying concern that I have that the DOJ is trying to get the court here in these new cases dealing with the $0 tax to treat all NFA restrictions as simply a shall issue scheme like what happened in Peterson. And that would take it from just being something a shall issue permit and that shall issue, analysis being applied to suppressors. And maybe they want to take it even further and say, we want to apply that to SBRs, SBSs, AOWs, and all of these other NFA items. So that's what's currently going on in these critical NFA challenges, which are trying to remove the remaining restrictions on suppressors, SBRs, and all these other items, especially now since they are no longer taxed. The Trump DOJ is using the Peterson ruling, which they told everyone to not be worried about, and they're trying to use it as a tool to now block all of these new NFA $0 tax lawsuits. We will now wait to see how these cases develop, but really the best case scenario would be for the Fifth Circuit en banc panel to take the Peterson case, reverse what the lower court said, and take away those arguments from the DOJ that they are currently trying to use to block these $0 tax lawsuits. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. You can also check out one of the two videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you all so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.